Hello, my name's Norm Keith. I'm a partner with Faskens. I work out of the Toronto office, and welcome to our short review of how to manage workplace risk during a pandemic. It's an honor to present once again for the Ontario Sewer Water Meter Contractors Association. I have represented many members over the number of years I've been practicing, and I'm delighted to be able to give you this short summary in dealing with the current COVID pandemic and how to reduce your legal risk throughout. Let's go through a few slides. Employers clearly have a public health responsibility to comply with public health legislation. We've just recently come out of a lockdown, which is an order under the Emergency Management and Civil Protection Act. So we've defaulted from that to public health guidance. Now, public health guidance also connects or dovetails with the Occupational Health and Safety Act. The challenge for many in the industry is that there is no health and safety statute or regulation that deals specifically with COVID-19 or even an infectious disease. However, the general duty clause under the Occupational Health and Safety Act for both supervisors and employers, the duty to take every precaution reasonable in the circumstances for the protection of the worker, is the link that the Ministry of Labor Training and Skills Development inspectors use to enforce both public health and safety, but also occupational health and safety rules for pandemic safety. So what do you need to know? Well, there's a COVID screening tool that has been presented under the Chief Medical Officer of Health for the province of Ontario. Regulation also requires a COVID safety plan to be developed. You need to have a written safety plan. If you don't, please give me a call. You're offside the law right away. But if you do, then it needs to be compliant. The COVID safety plan was last updated several weeks ago by legislation. It increased the number of questions one needs to ask for workers coming to the workplace. It also enhanced the precautions and the penalties for COVID safety plan compliance. So if you don't have someone in your organization that's updated your COVID safety plan, feel free to reach out to me. However, if you don't have a COVID safety plan, please give me a call and we can help. Let's talk also about vaccinations. We know that vaccines are hopeful. They're not coming as fast as we'd like in Canada, but they're important. Why? A vaccine prevents the person from getting COVID-19 as an infectious disease. It likely also helps them not to be a carrier and spread it. However, enough of your workforce, probably anywhere from 80 to 90%, have to be vaccinated to have what is often referred to in public health, community or herd immunity. So even if you only have half of your workplace vaccinated, it's as if no one's been vaccinated from the group perspective. So we aren't going to get into a long debate about our vaccinations, something you can require people to do by a mandatory order. You may very well be able to do that because of its safety directive, but I think to avoid union complaints or difficulties, you want to simply strongly recommend that people get vaccinations, as the Canadian Medical Association has. However, you should also think about a vaccine policy. So if people provide proof of vaccination, you want to record it, but keep it private. If people are refusing or have declined for perhaps medical reasons to get the vaccination, that needs to be provided for in your policy so you comply with human rights laws. Also, will you give people time off to get the vaccination when they're available? All of those issues can and properly should be dealt with in a vaccine policy. I'm happy to assist the association if they want to develop a general one for its members. So let's go on to a couple of other points. Health and safety law is not just about dealing with the COVID-19 pandemic, although that's top of mind for everyone. But a recent decision going to the Court of Appeal, the City of Greater Sudbury, following up on the Wyson case, is important for you to be aware of. It touches on vaccine liability. It also touches on risk. So we have a case going to the Court of Appeal, City of Greater Sudbury, which stands for the proposition, and this is the Ministry of Labor's position, that the definition of employer at the top of this slide is quite expansive. So that your party that you contract with, whether it's directly a municipality or a general contractor, will in fact, according to the Ministry of Labor's position in the City of Sudbury case, be their employer as well. Similarly, if you contract some of your services out to another party, their workers are not your direct employees from a common law perspective. However, they are workers for which your employer duties apply. So you can't contract out of the Occupational Health and Safety Act, and the City of Greater Sudbury case reinforces that more than ever. The Ministry of Labor is aggressively pursuing broader expansion of the definition of employer. So you need to make sure if you've contracted out any of your work that they, the contractor, and their workers meet your high standards. Due diligence for all occupational health and safety enforcement and charges is still a defense. In the two italics quotes from the Supreme Court of Canada, you have the outline or the legal definition of the defense. However, at a practical level, clients ask me, well, what does that mean? Well, the simple answer is it means an occupational health and safety management system. I'll explain a little bit more about that in a minute, but it's not just a binder. It's not just a paper program. It's that, but also implemented in an effective way, your health and safety standards in the workplace day after day. So you've got to have a COVID vaccine policy, a COVID safety policy, and that's part of your overall health and safety management system. But it's not just your health and safety management system. You have to deal with the other more typical and longstanding risks in the sewer and water main industry. Practical advice on due diligence means looking at the risks. So a good safety management system will identify and assess the risks that you have and that your workers are exposed to. Then, even if not required by law, you should develop a safe work procedure so you have a written health and safety policy for two important reasons. One, you're assessing the risk of a particular pipe attachment or type of work that you might be doing or trenching, and then you're putting it in writing. The second thing is that becomes the supervisor's guide and the supervisor's training and monitoring safety checklist for the workers. It doesn't have to be complicated. It does have to be written. And that's the evidence that you will be able to show to a judge or to the Ministry of Labor if something bad happens to say we've taken due diligence. You need to have proof of training, whether it's from the union or from other recognized providers. And then doesn't matter how much experience your worker has, they need to be trained by you on your health and safety management system, on your COVID safety plan, and on your vaccine policy. As I mentioned before, supervisors have to be very, very well-trained and qualified. In fact, they, by law, have to be a competent person. A competent person means a person who has been trained and is familiar with the Act and the regulations. That's why in 2 weeks, we're doing a course that we've done for years, myself and my team, for the Ontario Sewer Water Main Contractors Association on due diligence for managers and supervisors. Part of that course touches on the three elements of being a competent person. If an employer appoints somebody that's not familiar with the Act or the regulations, has not got the experience and qualifications to do the job, and thirdly, has communicated hazards to the workers they're supervising, they're by law seen as not fulfilling the competent person requirement. So what's critical here is that all of your supervisors meet the legal definition of a competent person. The next step or element in due diligence is being able to prove that, in fact, you are monitoring and enforcing your policy. Absolutely critical. I've had a lot of clients that have had policies and programs that cover all of their legal requirements, but they haven't monitored compliance and they haven't enforced by discipline those rules. Safety is not a part-time job at your job site. It has to be full-time. That means monitoring, that means enforcing the rules. Doesn't matter if it's beginning of the day, end of the day, the rules are the same. The men and workers have to follow the rules. And if not, you have to enforce it. Your management, you have that responsibility. And then ultimately, a health and safety program requires auditing. To become a system, a program needs to have auditing, needs to have feedback, doesn't have to be complicated. Obviously, in the core auditing program, you have a formal auditor outside of the company coming in. That's nice. If you're a smaller operator, you may not want to spend that money or can't afford it right now. But auditing in some form of your health and safety program is critical to its success. Senior management commitment, absolutely important. Engagement and motivation of workplace parties, critical. Integration of your safety program with your business operations is very important. One of my colleagues, Carl Oliver, and I are giving a presentation for a full-day course to the Ontario Road Builders Association. Some of you may be members on the 26th of February. What we're doing there is we're taking the cycle of business and integrating it with a safety management system. So we're training managers and supervisors to understand how to integrate their health and safety program with their normal operations. So it's not separate and apart from your business activity, it's integrated in it. It's important to think about going beyond minimum for legal compliance. However, legal compliance is important. Think about doing an audit or thinking about asking us to do a legal gap analysis to see if your program is in fact compliant. It's important to meet minimal legal requirements. And then once you're there, you can go beyond. Accountability and transparency is critical for a good, effective health and safety program. All of these steps, especially the ones in the last two slides I've just covered, are critical and conceptually integrated in the management of a safe business. If you do so throughout the COVID pandemic and beyond, you'll be a leader, you'll have a safe workplace, workers will go home healthy and whole at the end of the day, and your legal risk will be mitigated. So thank you for allowing me to present and remind you there's a bad picture of me, but my good looking team. If we can help you at Fasken's, feel free to give me a call, and thank you. And congratulations on another successful year under very challenging circumstances for the Ontario Sewer, Water Main and Contractors Association. On behalf of my colleagues at Fasken's and myself, wish you a very healthy and prosperous 2021. Thank you.